Welcome to the InfoSec Insider podcast, brought to you by URM, the UK's leading information and cybersecurity specialists.
Hi, my name's Annie and I'm here today with Rachael Salter, one of our senior data protection consultants here at URM. Welcome to another episode of Talk DP. So today in this episode, we're going to be discussing data subject access requests, or DSARs. So Rachael, my first question for you is, what is a DSAR and how do you recognise one?
Hi Annie. So a DSAR. So this is basically where an individual can direct a request to an organisation that processes information about them. All individuals have a right to see this information, more commonly known as a data subject access request, or shortened to the initials DSAR. A request can come into an organisation basically asking to see everything that an organisation processes about them. So how do we recognise one? That's the tricky part, I think, that often DSARs don't get noticed. And as we'll talk, as we go through, we'll talk about the timescales you have to process one of these under the legislation. So it is important that everyone in an organisation knows how to recognise one. Sometimes people don't use official terminology. So it may not say, I want to request my data under GDPR, or I'm putting in a DSAR and I want my information. It may well just be, I want to see a copy of, I want to have a copy of a record, I want to hear a voicemail that was recorded on my work mobile. I want to see a copy of my HR reports. It could come in so many different ways. So they don't necessarily have to mention the legislation, which is what makes it tricky for people in an organisation to spot one quite quickly.
Can a company refuse to process a DSAR? I've heard the term sort of manifestly unfounded or excessive before. What are those grounds under which you can be refused?
The only enhanced right under the GDPR is the right of access, which means that technically speaking, everyone can make that request and it can't be refused unless of certain other circumstances. So it can be refused, but there is a very strict criteria as to how and when that can actually happen. Manifestly unfounded or manifestly excessive are the terms that are used in the legislation and used quite often by the ICO. They can be used to refuse to process a DSAR under Article 12.5 of the GDPR, which is the section all around that. However, the obligation is on the company to be able to prove that that a request is manifestly unfounded or excessive. And that's also very difficult to evidence. The legislation is very weighted to the data subject, so it can be quite tricky to refuse it. You have to have very strong grounds to be able to do that. So if a DSAR is not regarded as manifestly unfounded or excessive, there are other exemptions as well that we can apply. So exemptions are there to say, if we don't have to do something, we can rely on an exemption to stop us having to pass over information or make a disclosure. And there are a number of different exemptions that could apply, but each organisation has to look at each one on its merit and decide which is the most appropriate when refusing a DSAR, because it's very tricky. To put some context around it, if you refuse a DSAR, the data subject has the right to go to the ICO, the UK Supervisory Authority, and complain that your organisation has refused their request. And the ICO will come to you as an organisation and say, explain why. What is the reason you cannot process this DSAR for this individual? So it is important that you have a solid excuse. So you have to be able to evidence manifestly unfounded or manifestly excessive, or you have to have noted what lawful exemption you can apply. So, for example, some of the more common ones, there's lots of them. We wouldn't have time to talk through them all today, but there are a few that are quite common. Legal privilege. You may have heard of legal privilege. This is where communications between an organisation and their solicitors or their lawyers, where there's direct communication between them around something maybe to do with that individual, that is legally exempt under a legal privilege, which means that we don't have to disclose that. So let me give you an example of that. If, for example, someone is leaving an organisation, they're being made redundant and maybe we're paying them a premium to leave. We may be having discussions with our lawyers, the business lawyers, around the value, or we may be paying them more than required to let them go sooner, for example. So those negotiations around that pay and how we get rid of that individual, how we manage that situation, that's legally protected because it's legal privilege. So that means we don't have to, in that subject access request, disclose those conversations between the organisation and its solicitors. That's quite a common one. So that's quite a big and overly used exemption. Confidential references. So when we work in an organisation, we'll often have references between from our organisation when we join the business, and when we leave, our organisation will send references to our new organisation. Confidential references, if they're marked as confidential, we can actually exempt them. So we don't have to add them to the bundle when we make a disclosure to somebody. We can remove them. Exam scripts are also exempt. So if you were someone making a subject access request to a university or a school or an exam board, they wouldn't release your exam script. Even though it's got your name on it and your identification on it and your writing and all of your comments, it's all of your information, it would be exempt under the legislation. And also, the most common used probably is where there is third-party information also included in the bundle. So, for example, if I asked for my records from URM, if I said, I want to see all of the records about me, if within some of those records, there are records about other colleagues who I work with or conversations between other colleagues about myself, that can be exempt using the third-party exemption. However, there is a get out clause here where the third party information could technically be redacted from the documentation, so removed effectively, so that if I was to read the bundle, I wouldn't be able to see that Annie had said something about me because Annie's name would be removed from the bundle. Have to be very careful here, though. We could talk all day around this because we have to be very careful around context, because removing someone's name is not necessarily the only identifier. If I know that there was a conversation between myself and Annie, and somebody took the name Annie out, but I understood the conversation from what was written in the documentation, I would know it was Annie without Annie's name being there because of the context of the conversation. So it's very difficult to exempt something using third party. If you redact it, you have to be very careful around the context and making sure that you remove every other identifiable factor. He, she, them, neighbours, next door, upstairs, downstairs, office, all of those types of terms can identify someone effectively. So we have to be very careful with that. But where there is third-party information within a file, we can consider the rights and freedoms of that individual. We can say, is it fair to release that document to Rachel where Annie said something about Rachel? Or is that going to cause detriment to Annie? So we have to think about what the impact is on Annie at that point. Whose rights outweigh the other? Which is fairer? Which is correct? We could speak to Annie and we could say, Annie, we want to release this bundle to Rachel, this information, your name is there. Are you happy for that to happen? So we can ask you your consent to stay into the document, and you may agree or you may not. We could say that actually we don't feel it's that detrimental to you. You said lovely things about Rachel, so actually why would we take that out? There's nothing bad in there. It's not going to cause any controversy. So we can leave that information in. And we have to go through a process at this point of deciding what's right. What's the right thing to do at this point? Do we take Annie's information out? Do we leave it in? What's the impact? Or do we just redact everything out of it so there's no context? Then Rachel can't work out who said those things about her. So these are all exemptions that we can apply. But manifestly unfounded and manifestly excessive are quite difficult to evidence. So the legislation doesn't tell us what manifestly excessive is, because what's excessive? I could say to you, what do you think is excessive? And you could say 500 emails is excessive. I could say 20,000 emails is excessive, because we all have a different view on what that is. And the legislation doesn't give us guidance. It doesn't say 30 or more records is excessive. Now, if you are an organisation that has been trading for a long time and you have an employee who has been in the business for 15 years, you will probably have 15 years worth of HR file of that individual. Now, if that individual then said, I want to see all of my HR file, is that excessive or is that a reasonable request? It's not the individual's fault that they've been there for 15 years and you've accumulated 15 years worth of data. That wouldn't be deemed as excessive. So it's fair that they could ask to see that record. Now, this is something that an organisation, when a DSAR comes in, they have to sit and consider all of these factors. Do we think it's excessive or not? Do we think it's too many records? Do we think that they're doing this deliberately to cause pain to the business? Now, this happens a lot. Individuals often, when they're upset at an organisation, when they're unhappy with the service they've received, or they're disappointed in something, perhaps they've been let go in a restructure, perhaps they've been made redundant, perhaps they didn't get along with their line manager, whatever it could be. And they could feel quite hurt by the organisation. And a very easy way to get back at them is to put in a subject access request, because that's going to cause them some pain because of the time it takes, the work that needs to go into it, all of the resource, all of the research. It's going to take time. So it's going to cause them some pain. Now, that's what we call manifestly unfounded, where someone has made a request to an organisation just to cause them some trouble, just to cause them some pain, to make it difficult for them. But to be able to refuse it using that as an exemption, you have to evidence that that is the case. And it can be very difficult to prove that that person has deliberately put in this request to cause an issue for your organisation. How do we actually evidence that? We might know it, we might feel it, and they may have said when they left, I'm going to put in a subject access. I know that's going to cause you trouble. You've only got so long to do it in, so I know it's going to be a pain. They may say that to us, but how do you actually evidence that that's the reality? Because they could turn around and say, no, I definitely need it. I need this because I want to understand something, or I need it because it will help me to rationalise why I was made redundant, or whatever's happened within a restructure. But how do we prove that they are doing this deliberately to cause pain? And this is why it's very difficult to actually refuse it on that basis. And if someone goes to the ICO to complain that you have refused their DSAR using that as an exemption, the ICO will ask you to evidence that. And that's the hardest thing to do. So yes, you can refuse them, but it's very tricky. Often the time it takes to refuse a DSAR, to find an exemption, to tell the person that, and the pain you're going to get coming back when they complain, and the issues when they go to the ICO when they complain, sometimes it's just easier to process the DSAR than it is to actually go through a refusal. I think the most important message is that if it's not obvious and clear how to refuse a DSAR, that you should just plough ahead and process it in the time that you've got to do it, because often evidencing that something's excessive, or that it's manifestly unfounded, or applying another exemption can often cause you quite a lot of to and fro with the data subject and the ICO when they get involved. And saying to the ICO that we have 500 records on this person's HR file is not an excuse. That's not excessive. That's quite reasonable if that person's worked with you for a period of time. So it's worth considering when you're going through this process. Can I get rid of this DSAR? Can I refuse it? Can I send these people away? What's the backlash for that? What does that mean for you as an organisation? Because if the ICO have not got involved with your organisation up to this point, and you start to refuse your DSARs using an exemption that's a little bit weak, or using an excuse that it's an excessive request, then the ICO suddenly will know who you are and what your organisation is, and you're suddenly on their radar. They will be watching that you are not deliberately shirking your responsibilities under the GDPR Article 12.5 and refusing to process DSARs. So sometimes it would just be easier to process it and go through the correct channels and fulfil your obligations as a data controller and get the DSAR process than it is to refuse it.
Thank you so very much for sitting and chatting with me today, Rachel.
You're very welcome.
For anyone who wants to find out a little bit more about DSARs, Rachel's written a really excellent blog that's up on our website, urmconsulting.com. It's called Everything You Need to Know About DSARs. So thank you very much for listening today, and we'll see you next episode. If you've enjoyed this podcast, we would really appreciate it if you could spare a moment to leave a rating or review at ratethispodcast.com/InfoSec Insider. To listen to more episodes, you can find us on Spotify, Apple Podcasts, YouTube and Podbean.
Thank you for listening to URM's InfoSec Insider podcast. For more information, visit our website at urmconsulting.com.